Hello friends, the question of standard of proof and principles of appreciation of evidence are not one and the same in civil cases and in criminal cases. In civil cases, preponderance of probability is the criterion, and in criminal cases, proof beyond reasonable doubt is the acid test. What is this preponderance of probability? In civil dispute or in any civil suit, there will be two parties, plaintiff, defendant, or plaintiffs and defendants. Plaintiff side leads evidence, thereafter defendant side leads defendant's side evidence. Thereafter, after hearing the argument from both sides, the Honorable Court has to weigh the evidence led by both sides, and the court has to consider which party's evidence and version is more probable, which version, which evidence appears as more acceptable, more genuine, more authentic, more natural, or whose version is more trustworthy. So that is preponderance of probability, or the court has to apply its judicial mind to weigh the evidence of both sides to see which party's evidence en masse or the version is more probable. The judgment will come in favor of such party whose side evidence appears more probable and more credible, genuine and acceptable under law. But as far as criminal case is concerned, generally the burden of proof of any allegation or accusation entirely lies on the shoulders of the prosecution side, one who complains, one who makes charge against the accused. He has to prove the guilt of the accused beyond any reasonable doubt. What is this reasonable doubt? It does not include any fancy or artificial doubt which can be created in the mind of the judiciary by so many stratagem or tricks. But in spite of evidence from the prosecution, even if there is no evidence from the accused side, if the Honorable Court is not convinced, if the court feels some doubt about the allegations made by the prosecution against the accused is entitled for order of acquittal. In case court forms two opinions in its mind at the end of the case, one view favoring the prosecution, one view favoring the accused, then it is also settled law that the judiciary has to lean in favor of the view which is favorable to the accused, for the simple reason that at any cost an innocent person shall not be condemned or penalized. Let me give one simple example. Take the case of dishonor of check. For that matter, civil suit for recovery of money or for compensation can be filed. Simultaneously, criminal or quasi-criminal proceedings under section 138 of Negotiable Instruments Act can also be filed in India. In a civil case, plaintiff leads evidence, defendant won't lead any evidence. Then court will hold that the plaintiff side evidence seems genuine and acceptable. There is no contrary evidence from the defendant side. In fact, adverse inference can be drawn against the defendant for not stepping into the witness box under section 114 clause G of the Indian Evidence Act. So plaintiff's suit can be decreed. In the the same subject matter in the criminal case under section 138 of NI Act, the plaintiff who is complainant therein, during cross-examination, if he says that I have not seen the accused putting this disputed signature on this check. My sister has seen, she was present at my home when the transaction took place. But the complainant won't examine his sister in that criminal case to prove that fact. And the complainant won't send that disputed signature for comparison with the handwriting expert under section 45 of the Indian Evidence Act, because it is disputed by the accused. Accused won't read any evidence. Now, there is a high possibility that the court can acquit the accused because there will be some genuine doubt in the mind of the court regarding the authenticity of that disputed signature appearing in the check, which is not proved beyond reasonable doubt by the complainant as that of the accused. Mere signature is not sufficient, its execution has to be proved. The accused had voluntarily, knowing the consequences, had put signature on that check and negotiated or delivered it to the complainant for discharging any debt or liability. That has to be proved by the complainant. So in that case, under those circumstances, even though subject matter is one and the same, because of this difference of standard of proof and principles of appreciation of evidence, in civil cases or in that civil case, plaintiff can succeed. In the same subject matter of criminal matter, the plaintiff may fail. Thank you.